Mr. Dice, you may begin now.
Thank you, Chairman Johnson, Ranking Member Scanlon, and members of the committee. I'm Jeremy Dice, and I serve as Senior Counsel for First Liberty Institute, a nationwide legal organization dedicated to defending religious liberty for all Americans. Thank you for your very kind invitation to testify here this morning. The Freedom to Access to Clinic Entrances Act promises to ensure access to the nation's reproductive health facilities and accountability to those who would unlawfully restrict access to those facilities. The law is quite clear. If you attempt to injure, intimidate, or interfere with access to a reproductive health facility, then you may face both criminal charges and civil penalties. The FACE Act is intentionally broad in its scope, affording protection to facilities that provide services, quote, relating to the human reproductive system, unquote. Pam Hibbard provides reproductive counseling every day to women at her facility. She also lives there. One morning, she woke to find shattered glass strewn about the ground. Her facility had red paint dripping down the outside walls as if it were blood. On the sidewalks, clients seeking access to reproductive services would have to walk over spray-painted threats. Pam did not know if she was safe, nor if her clients would be safe. Not far away, Jill Jurgensen woke to a similar scene at her reproductive health facility. Vandals had shattered the glass of the front door of her facility. Clients would soon arrive to find spray-painted threats on the threshold. These scenes played out across the country more than 100 different times following the decision of Dobbs versus Jackson Women's Health Organization just last year. Yet despite these numerous attacks to life-affirming reproductive health facilities, the Department of Justice has indicted just 4 individuals under the FACE Act in the past year. More concerning is the response of state attorneys general. The FACE Act explicitly authorizes state attorneys general to seek civil penalties on behalf of the citizens of each state against those who engage in such unlawful acts of intimidation. Yet in Massachusetts, rather than deploy the FACE Act in defense of Pam and Jill's facilities, former Attorney General Maura Healey threatened them with sanctions. Then the Massachusetts Attorney General issued a consumer advisory against the very centers who suffered broken windows, paint bombs, and spray-painted threats from Jane's Revenge. Florida tells a very different story. Martha Avila showed up to her reproductive health facility in Hialeah, Florida on July 4th of 2022, only to discover a threat from Jane's Revenge. If abortion is not safe, neither are you. Her experience, though, is different from Pam or Jill's. Once Florida Attorney General Ashley Moody knew the name of the vandals who allegedly attacked Martha's facility, she filed a lawsuit under the FACE Act to impose the maximum civil penalties against them. The FACE Act is, and ought to be, indifferent to ideology. It is meant to hold accountable those who use violence to express disagreement. Its application should not be withheld because a government official disagrees with the facility's religious beliefs. In Florida, the DOJ investigated and indicted the alleged vandals under the FACE Act. That allowed the Florida Attorney General to file her suit on behalf of the state, and it also allowed First Liberty to defend Martha and Heartbeat of Miami in a private legal action under the FACE Act. Had the DOJ and the Commonwealth of Massachusetts similarly identified potential FACE Act defendants, our clients there, and perhaps elsewhere, may have had recourse under the FACE Act as well. Violence is never an appropriate response to disagreement, and those who would so express their disagreement with life-affirming reproductive health facilities must be held accountable under the law. Applying the FACE Act equitably simply ensures that our nation will not tolerate violence as a means to political ends. Thank you again for this opportunity to testify here this morning. I'm happy to answer your questions.
Thank you, Mr. Dice. I said in the opening, and I'll reiterate here again as we begin the questioning period, that we believe that the facts show that the Biden administration has shown a clear double standard of enforcing the FACE Act in a way that protects pro-abortion activists and facilities while substantially ignoring attacks on pro-life advocates, facilities, and churches. And it is a disgrace that the Justice Department would rather cater to the pro-abortion political movement than protect places that assist pregnant women in need. I'm going to start just with a brief question of Mr. Dice. From your observation and firsthand experience in litigating these matters, do you agree with our assessment that the current Department of Justice is engaged in selective enforcement of federal law based purely on political motivation?
Thank you, Chairman Johnson. Congress passed the Freedom to Access Clinic Entrances Act to uphold the rule of law in this country. And after a year in which we have seen over 100 different instances of attacks upon life-affirming reproductive health facilities, and as Ms. Del Turco just testified about, even more against houses of worship, it's incumbent upon our leadership to ensure that the full weight of the federal government and the law is being applied. I think the American people would have no less expectation of this committee than to insist that its laws be applied equitably and across the board. And the problem that we have, if I may just wrap up, I'm sorry, is that in order to prosecute these claims, the most difficult part of the entire process for us as lawyers is to have a name of someone to prosecute. And that starts with General Garland. If his DOJ is able to provide to us a name after an investigation, we are happy to utilize the laws that you have passed to defend these reproductive health facilities from the noxious attacks that they've had to withstand over the past year.